We just listened to the first 2 episodes of a new podcast, and we want to tell you all about it.
The show is called Nobody Should Believe Me, and it's a groundbreaking investigation into Munchausen by proxy. Anyone who listens to Murder Sheet knows we really appreciate a deep dive into a subject. Well, no one has ever done anything of this depth and breadth on the topic before. You will be enthralled by the stories it tells, but even more importantly, you will learn a great deal about how to keep kids in your community safe from harm.
But what makes this show different is that the host of the podcast, novelist Andrea Dunlop, has a uniquely personal connection to this subject. Someone close to her was investigated for Munchausen by proxy a while ago. So to her, this is not just something that happens to other people. Her personal story really gives this show an emotional punch.
It also means she really makes an effort to get at the humanity of all of the people involved, all the victims and survivors. This isn't a podcast that focuses on the gruesome details. It has heart. Andrea really uses her storytelling skills to help us get to know the wide variety of people whose lives have been affected by Munchausen by proxy.
New episodes drop every Thursday. Listen and subscribe to Nobody Should Believe Me on Apple Podcasts or wherever you listen to podcasts.
We get support from Audible. We've all got busy schedules. And I'm sure sometimes you feel like with all the things you have to do, it's hard to find time for the stuff you love to do, like reading. That's why Audible is so great. Audible offers an incredible selection of audiobooks across every genre, from bestsellers and new releases to celebrity memoirs, mysteries and thrillers, motivation, wellness, business, and more. Plus, as an Audible member, you can choose one title a month to keep from their entire catalog, including the latest bestsellers and new releases. And also, I have to say, I love how the Audible app makes it easy to listen anytime, anywhere, when you're traveling, working out, walking, doing chores, wherever your day takes you. Cleaning the bathroom has really never been more fun. Let Audible help you discover new ways to laugh, be inspired, or be entertained. New members can try it free for 30 days. Visit audible.com/listening or text listening to 500-500. That's audible.com/listening or text listening to 500-500 to try Audible free for 30 days. Audible.com/listening.
Content warning. This episode discusses the murder of 2 young girls.
People have a lot of questions about what's been happening in the Delphi case. What does it mean that Kegan Kline was temporarily transferred into the custody of the Indiana State Police? Is it possible Kegan Kline has made some sort of deal with prosecutors? Why would prosecutors even consider making a deal? Why did it take so long to arrest Kegan Kline after the raid on his home in 2017? And what about that probable cause affidavit to search Ron Logan's property? Does that mean Logan is guilty? We decided to go to the experts to get some answers. So we turned to 2 familiar figures in the true crime space. Brett and Alice have a great deal of experience in criminal law and co-host The Prosecutors, a popular podcast where they break down true crime cases in a fascinating and accessible way. We've always really appreciated the terrific legal analysis they apply to the cases they discuss. That is why we decided we really wanted to talk with them about the recent developments in Delphi. My name is Anya Kane.
And I'm Kevin Greenlaw.
And this is The Murder Sheet, a weekly true crime podcast.
Anya and I connected over the Burger Chef Murders, a 1978 unsolved case involving the killings of 4 young restaurant employees.
Now we're looking to track restaurant homicides. To help us understand the patterns of these crimes, we created a spreadsheet of nearly 1,000 eatery-related killings, the Murder Sheet. We'll be drawing on that data throughout Season 1 to give you a deep dive into undercovered crimes. We're the Murder Sheet.
And this is the Delphi Murders, a conversation with the prosecutors.
So, okay, one facet of this situation that we've been reporting on that I think a lot of outsiders point out is that it sort of seems a bit unusual for a person like Kegan Kline in this case to be held and incarcerated for so long without trial. He was arrested in August 2020, and now we're getting into September 2022, and still nothing. And it's likely not going to happen until 2023 at this point. So, as prosecutors, like, how do you guys view that situation?
Well, it's actually not that unusual. It varies from place to place. You got to remember, COVID's a big factor too. It's hard to say exactly where we'd be if it weren't for COVID. Maybe things would have moved more quickly. Another thing, different states have different rules. I mean, you have a constitutional right to a speedy trial, but how that's been effectuated is a little different depending on where you are. There are federal laws that give you certain speedy trial rights, but this is a state action, so that's a little different. A lot of times people in state court, state cases can drag out for a long time. The other thing I will point out, and I don't know how long this has been the case, but it certainly seems as though it's been confirmed recently. If he is engaged in conversations with the prosecution, with the government, about possibly giving them some sort of supporting information or cooperating and pleading guilty, that is going to continue a trial. As long as those are good faith and everybody agrees we're working in good faith, we're working towards something, no judge is going to say, well, too bad, we're having the trial next week. And if you're somebody like him, the charges that he faces are serious. The evidence against him is weighty. The chance of him prevailing at trial, it's possible, but it's unlikely. Anytime he serves in jail right now will count towards his eventual sentence. So for him, there's not as much impetus to get to trial as maybe some other defendant might have.
Yeah, kind of to add to that, that's exactly right. Typically what people don't understand is when a defendant is awaiting trial for a long time and it keeps getting pushed back, it's almost always at the request of the defendant, or at least with not over the objection of the defendant. And this often happens here, especially if there's cooperation. It doesn't have to be that case. So oftentimes we'll see defendants run into court and say, we waive our speedy trial rights because the discovery is voluminous, discovery is ongoing. We want to do our own investigation. That could be a good defense, but these people are to the wind and we need to find them, judge. We need more time to develop our case. Almost always the judge is going to give the defendant their time because remember, the prosecution has up until the statute of limitations, kind of all the time in the world to prepare their case. The defendant doesn't have that. For the most part, the defendant doesn't know until they're charged and arrested. And so their investigation period starts then. And the judge recognizes that and will take that into account when granting the defendant's request to delay their trial. And what Brett says is a really, really good point. We often have under seal request to delay trial because we have a cooperator, and they're under seal, not public to the public, because we don't want anyone to know they're cooperating. It could thwart the investigation. It could, cause their cooperation to come to an end, because if they're part of a gang, for example, the gang members will know that they have an insider who's a mole. So it doesn't necessarily mean any of those things. But those are all very common reasons we see for delay in trial that has nothing to do with we don't have enough evidence against someone, or we're holding them, against their will for however much time because we don't have enough to go to trial.
Now, I will say in this case, obviously, it's hard to know how much COVID has affected this. That's just an unknowable. And it's hard to say just how much the local docket is just really full, and so it's taken time to get to a trial. Having said all that, I do think it tells you something in that with the amount of evidence the prosecution has, ordinarily this kind of case might move more quickly than this one has, which I do think leads you to believe that some sort of conversation is ongoing, which seems to have been confirmed. Just to piggyback off what Alice said, and not to get ahead of ourselves, but one thing that I thought was unusual is that the order transferring him to the ISP's custody was unsealed so quickly. It did not surprise me that it was filed under seal for all the reasons Alice said. It's kind of surprising to me that they unsealed it. I would have wanted to keep that sealed until everything had sort of been figured out. So don't really know what's going on there, but it's not surprising that they sealed that initial order.
What does it suggest to you when custody is temporarily transferred from one legal agency to another?
Honestly, it's less exciting than what it may seem. And here's why. Almost everyone who is facing serious time is going to say at some point, if they want to cooperate at all, to their lawyer or law enforcement, I have information that's going to help you and you really going to hear my story. For the most part, it's going to be just not true. Everyone's going to say, I heard over jailhouse calls. I know who murdered so-and-so. I can solve John Bonet. I mean, this stuff happens all the time. But if the police have reason to think that what this person has to say really will be helpful in their case or another case, they will go through the transfer of custody, a writ, in order to have a proffer. A proffer itself doesn't say that much, except that you've gotten over the baseline of this isn't BS. There might actually be something there. But proffers are kind of it doesn't cost either party very much. What a proffer means is an interview. That's all it means. It's an interview where you're bound by some sort of contract. And the contract is typically something like, person who's telling us information, you have to tell the truth. We can't use what you say against you, but we can use that to follow up and investigate. And if we find independent things that's incriminating against you, we can use that against you. And we do not promise you anything in exchange. So the law enforcement actually holds all the power, even if they're writting someone over to proffer. Proffer is a fancy word for interview. They are still not saying we're not going to offer you anything on paper. We don't know yet, because many, many times someone will get written over, they will proffer, and it's everything law enforcement already knows. It's not helpful, and they're not going to get credit for it. Credit comes in many forms. It can come in the form of, credit in some way for the sentence that they're going to, the law enforcement is going to ask for in court. It could mean nothing. It could literally just look good for argument when your defense counsel is saying, see, this guy's turning his life around. He wants to help solve their cases. He's already, cooperating. Judge, give him a lighter sentence. And so I've given you kind of a broad range of things. All to say is proffers actually happen very often. As soon as you kind of get over the baseline of, I think this guy actually has something to say that might be helpful, let's hear what he has to say. Law enforcement has to give nothing up, and therefore it's not that huge of a deal to writ someone over for a proffer. So that's one side of the coin. I'm sure Brett will give you the other side.
Well, I just wanted to echo something Alice said at the very beginning. I think it is always important to remember that just because someone is talking to the police doesn't mean they know anything. And a good example of that, a case we often bring up, is Aisha Degree. I don't know how familiar you guys are with that. I'd love to see you guys tackle it. But it's a young girl who disappeared in North Carolina under extremely strange circumstances, just a very unusual disappearance and unsolved to this day. And literally a couple of years ago, there was an local inmate in North Carolina, who said he had information on her disappearance and knew where she was buried. And people got really excited, and we talked about it when we covered the case. And we said, everybody just pump the brakes, because they're going to talk to him eventually. And unfortunately, most likely, there will be nothing to this. And sure enough, at some point, he's taken out of custody. He's taken to whoever's investigating, and they talk about it. And it turns out he doesn't know anything. The difference here is, I think it's pretty obvious, or it seems there is something going on with Kline, or the Klines, and this case. There is some connection here. So it's not your typical, which is literally just some random person. This happens all the time for us. We'll get a call from some defense attorney and says, hey, I got a client. Maybe he's in prison, or maybe he's been indicted. There's all sorts of things. And he knows some information he thinks would be useful for you. And usually the next step is, okay, fine, let's get him on the phone. I'll give you an example. I had this happen for a guy who was in prison. He was serving a 40-year sentence, and he didn't want to serve a 40-year sentence. And so he gives us a call and says he has some information that we'd be interested in. Well, the first thing we did was he said, okay, fine, let's do a phone call. We're not going to waste our time with you unless you can give us some indication that you're not just one of these people who's making something up. And, we did a phone call with him he was in the infirmary because they wanted to make it look like he was just going to the doctor. They didn't want everybody else in the prison to know. And then once he talked to us, we talked with our law enforcement partners and thought, yeah, this could be something. So at that point, we did exactly what they did in this case. We filed a writ, and we had him transferred over to our custody. He was brought to us. Like, we don't go to them for several reasons. I mean, number one, you always want to maintain I don't really care about you or what you have to say. I am doing you a favor. So if you want to come over here to where I am and tell me whatever it is you want to say, maybe I'll listen, right? Because you never want them to have the upper hand. But you take them out of custody, you bring them wherever you are, and you have that conversation, and then you follow up. And you look for some, and that was exactly what happened in my case. Guy comes in, he gives us information. We send him away with no promises. We looked into it. We're able to corroborate some stuff. And sure enough, he got some time off his sentence, right? So everybody was happy. And I think that's what you're seeing here is you have that initial connection. There's obviously some connection here. And I would say one of two things happened. Or let's say there's one of three things that happened. The first that I think would be the most hopeful, the most optimistic would be he told his defense attorney something that indicated he's finally willing to cooperate fully. His defense attorney calls the prosecution. They look into it and say, this is something we want to hear. They bring him over. He gives good information. That's the most hopeful. The second would be this is prosecution driven, which is less hopeful just because whenever the prosecution is reaching out, it kind of means there's a little bit of desperation there because we don't like to reach out. Because like I said, we don't ever want to give up the upper hand. Could be that they've learned something. This is the second most hopeful. They've learned something. And now they can bring him in and say, look, we know this now. So this is your chance. If you're gonna tell us what you know, now's your chance. And if you don't tell us, it's off the table and good luck in court.
And just so you know, that's called a reverse proffer.
Right, exactly. When you've got the information, you bring them in and you tell it to them, and that's their opportunity to come clean. If they don't come clean, you get a trial. The third would be, we're just sort of doing a reinvestigation. We've talked to you before, and we just want to go over it again with you. And so we brought you out here to talk. And that's really the least hopeful. I mean, stuff can come from that, but that would be sort of the least hopeful circumstance. And obviously, nobody but the people involved know exactly why this happened, though indications by the defense attorney that they are working towards something would seem to mean that hopefully we're in a situation 1 here, not a situation 3.
Absolutely. I wanted to touch upon something Brett mentioned and just, obviously might be some speculation here, but you mentioned the whole sealing and then unsealing the kind of transfer of custody element of it. And we were just curious, like, would there be a strategic reason for for the prosecution and the law enforcement to possibly take that route? Or is that something that's just very unusual and it's kind of hard to know what they were thinking?
So this is total speculation. I mean, there's a couple things that could be going on. Number one, it could be a matter of state law. There may be a rule that says sealed things can only remain sealed for so long until they have to be unsealed. I mean, there are states that have much more open records because of sunshine laws, and they want the press and everyone else to be able to report on this, and there's a First Amendment interest. Could have something like that. I don't know Indiana law well enough to know.
Definitely not that.
Okay,
Right.
Well, it's not that. Well, if it's not that, then I can't think of a strategic reason. I mean, maybe Alice has a better idea.
Yeah, I can't think of a strategic reason, except typically what governs whether something is sealed or not sealed is a need for it to be sealed. So typically, if someone's going to challenge that it's sealed, let's say the subject of the warrant can actually say, this doesn't need to be sealed. And that part is all sealed, actually. So that is not public to anybody. And if the government cannot articulate an ongoing reason to need to keep that document sealed, the court may go ahead and grant the unsealing of it, or the government can move to unseal it. Either way, you can do it proactively before the court asks you to do it if there is no reason to unseal. So they could have been forced to unseal because they knew they had to because there was no reason. Maybe that information was already out in the public. Maybe at this point the information was stale. Maybe they couldn't show that their investigation would be thwarted with the unsealing. That's all I can think of, because I can't think of a strategic reason that you would want more information out there when you have seemingly so little information that you already have. Does that make sense?
Yeah.
Honestly, the more the public knows, the more difficult it gets to do an investigation just in general. Us in the podcast world, we love information. Us in the law enforcement world, it makes it more difficult for all the reasons you can imagine. More cooks in the kitchen, more false tips because people think they know more information and they're connecting dots that don't exist, and they can kind of jam up your hotlines. And so that's why there's always this tension between information to the public or not. But coming from the law enforcement world, it's just true. The more information out there, the harder it is to do your job covertly.
I'd like to zoom out for a minute
One comment we've gotten from people is, they see these comments from Kegan Kline's defense attorney talking about negotiations and process, and people say, why do people like Kegan Kline even get deals at all? Can you speak about the role of plea bargains and deals in the justice system and why they're needed?
Yeah, so first thing, no defendant is actually entitled to a plea deal. Everyone is entitled to go to trial, but on the flip side, the prosecution never has to offer or accept a plea offer. Now, there are many reasons for the taxpayers and for judicial economy and prosecutorial resources to go plea deals, even if you have all the evidence in the world. Cases are expensive to try. They're time consuming. If you have victims, especially if they're underage or unwilling victims, they have to relive the worst days of their life, not just once, not just twice. They have to be prepped. They have to be interviewed, and then they have to testify in court because we have the confrontation clause of the Constitution that they get to be confronted by the person that's accusing them, the defendant does. And all of these things are things to take into account. Usually you will be speaking with the victims. If we have victims who are very opposed to a plea deal, we take that very heavily because we're trying to vindicate societal, justice, but also justice for the individual victims. But think about, what that's like for all the victims, all the witnesses that you have to bring to court. Brett and I just came off of a month-long trial. That wasn't 1 month long. That was 2 years of our lives. That was 2 years of taxpayer dollars, 2 years of flying around the country on taxpayer dollars, away from our families, talking with lots of witnesses who didn't really want to talk to us, and then bringing lawyers from all over the country into court for 4 weeks. I mean, the taxpayer burden there is immense, not to mention for about 2.5 years, Brett and I couldn't focus our attention on other types of cases. And so there are lots of reasons. I will say cases probably didn't get prosecuted that could have in that time because we were in trial. We physically could not, go to grand jury because we were in trial. And of course, they'll get prosecuted and whatnot. But there are lots of things to keep in mind as to why you go a plea deal, because once you sign a plea deal, that case, there's a lot that goes into it, but essentially is over. You can start moving on to your next cases. You could be saving yourself years of resources and also kind of a lot of heartache for victims. And those plea deals also often have something very, very important, and that is an appeal waiver. When you go to trial, you can always appeal if you lose the defendant. And that means a case can drag on for years and years and years. And there could be no finality for a very long time for the government or for the victims. A plea deal, because you're signing, an agreement, you're also agreeing, I'm not going to appeal this except for some very limited circumstances like prosecutorial misconduct or ineffective assistance of counsel. But other than that, you can't just say, I changed my mind. I didn't really like that 40-year deal that I, pled to. I'm going to appeal this to, the circuit court and say I should get something much less. You don't have to do that. And that saves even more resources. And again, gives that level of finality. So those are some things to think about as to why even some cases that seem so can if you can extract a deal that makes sure this person is, out of societal harm for a long time and can conserve resources and also bring finality to a terrible situation for a lot of people, it could be actually a much better choice than going all the way to trial where the jury is a black box. They could nullify. They could just be like, wow, this is some of the most horrendous things we've seen, but stick it to the government. We hate the government, so this person gets off no matter how horrendous they are. We've seen it happen, and it can happen. So certainty and resources are kind of big factors.
One of the things we always point out is your best witnesses don't come from the church choir. When you have these cases, a lot of times, if you have some really bad people, you need really bad people to help you convict them. And you just want your really bad people you help convict them to not be as bad as the ones you're convicting. Think about like mob prosecutions. A lot of hitmen have gone not free necessarily, but have had lower sentences so they could get the boss. And in this case, if what he's offering is, I can give you who killed these 2 girls, that is a deal you're going to make. And there's a couple things to remember. Number one, it doesn't necessarily mean he's going to go free. Well, the first thing I would say that people need to remember, and this is not something we want to think about, he's a bad guy, but there are a lot of people just like him out there. He's not the worst person that the people who investigate these sex crimes have ever seen. They deal with people just like him all the time. So from their perspective, yeah, he's a monster who needs to go to jail, but he's not the worst monster. And we'll have another monster next week. So if we can get these, whoever killed these two girls, let's do it. The second thing is, it doesn't necessarily mean he's going to go free. He's facing a lot. I mean, he has a lot of charges against him. You can knock off some charges. You can agree to a lower sentence so that he doesn't serve the rest of his life in jail, maybe, 20 years instead of 40 or 15 years instead of 20. It might be something he wants to serve his prison sentence in a certain place, closer to family. I mean, there's all sorts of things that you can agree to as part of your deal. And like Alice said, sometimes the deal is you will plead guilty. Depending on how the sentencing works in Indiana, they probably have some sort of sentencing guidelines. The government might agree. We'll go for the bottom. And you can argue that you were so helpful for that judge. And when you get in front of the judge, you can say, look, judge, we don't have an agreement. They didn't promise my client anything other than the bare minimum. That's all they promised him. But you know what? He was truthful and he told everything. And that shows he has remorse. It shows he can be rehabilitated. It shows he could have a future. Like, there's all sorts of reasons to enter into a plea deal other than absolute immunity. And I feel like most people, when they hear plea deal, they think, oh, it's absolute immunity. He won't be punished at all for these crimes. And I seriously,
we almost never give absolute immunity.
Yeah, I mean, almost never.
Like almost never.
That makes a lot of sense. You both kind of touched upon this, and this is something that we've kind of also has been made it difficult to report on some of this, especially around Kegan's charges, just because they're so horrific. And I think child sexual abuse materials cases really hit home for people, and it's just horrifying that what proliferates on the internet. And I'm just wondering, in your experience as prosecutors, or just being aware of other colleagues, kind of cases, are there any unique challenges presented by CSAM related cases in this era of the internet where it's so much is done on the dark web and sort of, not, you have to put a phone or a computer in somebody's line of sight, as opposed to maybe relying on physical evidence in a traditional sexual crime?
Well, I'll tell you what's kind of terrifying about them is the people that we catch are the dumb ones. And there's a lot of dumb ones, right? I mean, people who will download child pornography off the internet without a VPN, just straight onto their computer, and then they'll delete it and send it to the recycle bin and think they got rid of it. I mean, those people are so easy to catch, right? I mean, the people you're talking about, the people who are really sophisticated on the dark web, number one, they're really sophisticated. Number two, they're some of the worst abusers, because a lot of times in order to become a part of that community, you have to produce this material. So you can't just show up and decide you want to see it, because they're not going to let you into their club if you're an agent, if you're a federal agent or a state agent. So they want to see new stuff they've never seen before. So a lot of times you have these people who are not only viewing it, but they're going out and producing it so they can get in. And those are, I mean, I'll say this, there's a lot of focus on those. I mean, there's a lot of resources that goes into it. That's the good thing. Law enforcement will sometimes be a step ahead and sometimes be a step behind. I'm not going to say we're always a step behind, because we're not. There's a lot of times where law enforcement will get a step ahead and then there'll be a big bust and they'll shut down one of these networks and they'll arrest a bunch of people. But then the other networks see what happened and they realize what the hole was and they plug it. So it's a constant sort of battle here. And I think people would be shocked at the number of people out there who are involved in this stuff, and they come from every single walk of life. I mean, you see this guy and you're like, pedophile, right? I mean, like a picture of him, he does not, you wouldn't let your kids run around with that guy, right? But that is rare. I mean, usually these are people who, I've seen colonels in the military, I've seen pastors, I've just, everybody from every walk of life can be one of these people. I don't want to, scare everybody to death and lock your kids in the closet and never let them out. But sometimes that's what I want to do with my kids, because it is really scary.
Yeah, I mean, again, this is not to scare everyone about child exploitation, but the hardest part is it's like drinking from a fire hose. We are not going to catch everyone. And the hardest thing is to prioritize and get the worst of the worst. And those are the hands-on offenders and the travelers. Travelers are people who make contact, usually through social media, across state lines to travel to usually sexually exploit a child. And oftentimes it's through their parents. And that's what's devastating, is these are almost always perpetrated by someone who knows these children. And honestly, the only thing we have over going to trial with a lot of these people, because honestly, the internet makes it easy to prosecute because we can get so much of what they have. Forensics has come a long way. You can delete it. You can use VPNs. There's ways to get around that, so we can catch you with a lot of it. The one thing we have going over them is these people don't care, right? This is what they do for fun, is they don't want us showing those videos and those pictures in court of what they're doing to these children, because some people in their lives don't know that they do it. And that's basically the only thing we have holding over them. So this Kline guy, like, honestly, he's a dime a dozen. The stack on our desks of child exploitation compared to just about any other crime, it like pales in comparison, which is terrifying. We have small children. I'm probably going to lock my children up like forever, because I don't want them to ever be exposed to this. And they look like everyone you see on the street. I mean, I'm glad this is shining light on it, honestly, because of the proliferation of it. People need to know that it's out there, and to take measures to protect their kids and themselves. But it also shines light on the fact that this guy is unfortunately not that special.
Yeah, the other problem we have is law enforcement burnout on it. I mean, you have some people who are just absolutely dedicated to this stuff, and this is their career, and they do it. But a lot of people come in, they try to do it, they do it for a few years, they prosecute the cases for a few years, and they just can't do it anymore. They can't look at the photos, they can't watch the videos, which you have to do. If you're going to prosecute the case, you got to be familiar with all the evidence. And it's just, I mean, it just burns into your soul, right? I mean, you never get it out of your head. So that is also a big problem. Alice is right, though. I mean, most of these cases never go to trial. They never go to trial because these people do tend to be embarrassed, at least for some people in their family, about what they have, and the evidence is so bad. You know, you have 1,000 photographs and videos. It only takes one, and it's over. You show that to the jury, and that person's done. And going to trial means you can forget about having any leniency from the judge. This case I know is set for trial, I think, in early 2023. Number one, I don't think it'll go to trial in 2023, particularly if these things are true, that they're sort of working on things, that'll get pushed. And even if it doesn't, I mean, even if all law enforcement discussion breaks down and they're like, never mind, we're going to trial, see you at trial, I think eventually he'll plead guilty.
You know, I wanted to step way back a little bit, away from the Kegan Kline thing. This is another thing that we reported on. And one thing with the Delphi case that I'm sure, everyone who kind of has covered it notices is that, something new comes out and then the media runs with it, runs pretty hard. Sometimes, nuance is lost. And one thing I'm specifically thinking of is the Ron Logan probable cause affidavit.
Yes, let me ask a leading question about that. Is a probable cause affidavit for a search warrant written by a law officer, is that a place where you would expect to find a dispassionate discussion of all of the strengths and weaknesses of a case?
No.
Good leading question.
I mean, it's done in good faith, right? I mean, it's done in good faith, and it's a statement of things the officer knows or believes to be true in good faith. And so it's not as if he's making things up, but probable cause is a pretty low bar. It's a very low bar. And it just means you have sort of a reasonable belief that evidence might be in the place it's searched. And the reason you have this reasonable belief is because you have these factors you're going to point to. And I mean, we can get into the Ron Logan thing specifically, but I mean, Alice and I have done a lot of these. I don't know if you have more thoughts.
I mean, an affidavit is a piece of advocacy, because you are arguing to the judge, I do have cause for probable cause, and you're putting your name to it. I mean, that is very important for a law enforcement officer to sign their name to it, because they do have to appear before the judge and they have to raise their right hand and they swear to everything written in that document. So it is all in good faith. They have reason to believe all of it, but they are listing everything that leads them to believe there's probable cause. They are not writing a pros and cons list. of what there is, right? They're not going to leave out any information. If any of that information cuts against any of the evidence they have to go towards probable cause, they have to let the judge know. But they don't have to list all the reasons that there could be other reasons for it. Probable cause is just right down here. And they're saying, here's all the reasons that I have. Here's all my investigation. And of course, all my investigation has been towards this end. I'm trying to lead to the next step, and I need this next step. And here's everything I've done to lead up to this point. So, it is an argument to the judge that I have probable cause. And you'll see these, everyone has different ways of writing their affidavits. But we do emphasize that, you have to swear to it. But at the same time, it is a piece of advocacy for showing the judge, this is why you should sign this warrant.
And it is a window. It is definitely a window into law enforcement thinking, but it's a window into law enforcement thinking at the time the affidavit was drafted. And it is based on the evidence they have at the time the affidavit was drafted. So while it can be useful, if everybody who ever had an affidavit drafted against them in a search warrant was guilty, you'd have a lot more people in jail, right? I mean, a lot of times the police have a good faith basis, and these are arguments, and they look in a place, they don't find anything, and they realize later on, you know what? That person didn't have anything to do with it. We were totally misled, or just based on sort of what we were thinking at the time, that's the way we thought this investigation was going. But now with more information, we no longer, with all the information we have now, guess what? We wouldn't have been able to get a probable cause warrant. We wouldn't have been able to put that in an affidavit because we know so much more now. So I think one of the problems with that one was it was back right after, and correct me if I'm wrong, you guys know the facts of the case much better than I do, but it was right after the murders. I mean, we're talking, this is one of the immediate things. It was an obvious person to look at. I don't think there's any question that it was a good angle to go, but it doesn't seem like it really led anywhere. So looking back today at an affidavit from 5 years ago and saying, well, look at all this stuff they had. Well, yeah, that's what they were thinking at the time. If they issued that tomorrow, yes, that'd be huge news, and we should all be talking about it and breaking it down. But it's interesting, and it is a window into law enforcement thinking. But beyond that, particularly given its age, I don't think it's that helpful at all.
Yeah, I think we would tend to agree. I think candidly, when we first reported on that, we editorialized in our coverage of it, saying that, we think this is a window into the case in March 2017, a month after it happened. And we think it's obvious that law enforcement moved on. We had a very maybe overly academic kind of view of it, of kind of like, this is interesting because it tells us about the investigation. I think the media narrative that kind of sprang from it turned into more of like, we have footage of Ron Logan and here's the bridge guy, like, look at them, and so we were kind of like, okay, it's a good lesson to always editorialize when you're talking to people, I think. But
it made a great headline for a lot of newspapers, right? I mean, they were able to write a great headline out of that, and that's what they tend to do.
And look, sure I think they did understand your nuance, but that doesn't sell headlines, right? So
I'm sure in paragraph 20 on the third page of the article, they said all those things. It just took them a while to get there.
But yeah, no, if you guys have any other thoughts about the Ron Logan documents, that we'd be curious to get them. Because as we said, we found it very interesting. I mean, from us piecing together the timeline, because what we really are reporting on is the investigation itself, and not the internet conspiracies and things like that. Like we're kind of trying to put everything in order and say, sort of, why has this taken so long and what's going on possibly. And one thing we noticed was, the Kline household is raided about a week after the murders, March of 2017, Logan. And then we come back to the Klines circa 2019, 2020. Is that fair to say? And so we kind of thought that was interesting that the Klines were sort of Kegan Kline was sort of publicly cleared so quickly after the raid on his house.
Is it unusual in your experience for law enforcement personnel to spontaneously, publicly clear someone immediately after a search of the premises? Because that's what happened in this case. FBI agent Bob Ramsey told the press that Kegan Kline was cleared.
Well, I don't know. I mean, is there a reason the FBI was leading the sort of public discussion in this case? I mean, the FBI's role in this has never been entirely clear to me about
it's
what
not,
exactly, I mean, number one, I think there's no such, I don't know that there's sort of standard operating policy here. Like, I don't think you can say, oh, they would never do that, or they would do that all the time. I think in high profile cases, a lot of times you want to clear people because that if you know for certain that they're not involved, that shadow that hangs over you, if you're a suspect, just go back to the Atlanta bombing, right? I mean, that's sort of the big example of this. I mean, you can, and we've seen that in this case, I mean, there are people who think to this day that it's the sheriff, right? I mean, Tobe Lesenby gets all sorts of hate because there's people who to this day think it's him because he foolishly said that he was a suspect at one point, right? Probably shouldn't have said that. But so I don't know why they would do that. I don't know if there was some strategy behind that. I don't know why the FBI was doing that as opposed to ISP, because this has always been an ISP investigation. The FBI is assisting. There's no question about that. And the FBI will often assist in complex investigations when they're asked to do so. But so I don't know why he was doing that. And it's impossible really to know whether there was a strategy behind that or if it was just a tactical mistake.
Yeah, we've reached out to him to sort of get some clarity. We don't really understand the FBI's. We've heard things basically, and we've reported on certain mistakes that were made that we confirmed by the FBI. But of course, it's a complicated case, lots of different agencies, and we can also understand that law enforcement personnel are humans, and you can maybe just, human error could be a factor, and that's not necessarily surprising given that there were so many directions I imagine that they were going in. And I mean,
look, I say this sometimes when people get mad at me for it. And I'm not saying that I've ever personally been a part of this, but people should not just assume that the police always tell you everything or they always tell you the truth. Like, if they had a strategic reason to clear him publicly, if they thought this is the guy, we need him to slip up, we need him to think we're not watching, we need him to think because we searched him, but we didn't find what we needed, right? We thought we had him, but then we went in, we didn't find what we needed, and we need something else. We need him to slip up and lead us to more evidence. Then maybe you tell the public, yep, cleared him. And it's like, sorry, guys, we had to lie to you. I mean, if that's what it took to get the killer, I don't know that they wouldn't necessarily do that.
It's been interesting. And yeah, I think there's been so much speculation about police strategy about this. And sometimes, sometimes you have people, it's kind of almost like a litmus test for how you feel about the police. If you don't like the police, then they're just inept bumblers. And then if you do like the police, it's all part of some grand chess strategy. And it's like, I think both of us are sort of like, I guess we'll sort of see when the facts wash out, and hopefully that will be eventually, and hopefully there will be questions answered. I guess my thing is, like, as a resident of Indiana, I would want to know, what kept Kegan Kline from being prosecuted, at least for the child sexual abuse materials in 2017. Obviously, that's not why the police were talking to him. They were looking into this high profile case, and that, certainly is understandable that took precedent. But my understanding is typically I would think, like, if there's other serious crimes uncovered in an investigation, those would still be kind of looked at.
So it honestly depends, especially if they're tied to other illegal conduct, because you typically want to bring it all at once. And once you indict a case, you can't use the grand jury to continue investigating that case. And so if you indict too early, you may actually leave important investigative tools on the table. And so this happens, unfortunately, not infrequently. Like, we find out some big drug dealer moving a lot of drugs, and we can absolutely pop him for like massive amounts of meth and cocaine, but we don't, because we think he's also part of some like very dangerous crew that's murdering people up and down the coast or something. We would wait to bring the drug case, even though we could stem the drug importation right now, but that would then thwart hundreds of lives or whatever that they have at risk. And so if they know, and they know he's not currently offending because he can't, maybe they know that they've cut him off or they're watching him, and the next time he tries to lay hands on a kid, then they'll fly in, even if it thwarts their other investigation. They usually have an eye on it. And if they have a control of the situation and no one else is getting hurt, they may hold off on indicting so that they don't thwart their other investigation at the same time. So it doesn't mean the police aren't looking at it, but I bet you they probably had him being tracked all over the internet and making sure that he wasn't doing that type of activity.
Yeah, there's a lot of people out there who are committing crimes right now who the police know about, and they are preparing cases against them, and they're getting ready to move on them, and it may be a while. It's certainly not the case that as soon as you realize somebody's committing a crime, we got to go arrest them. In fact, it's very much the opposite. I mean, you see this as Alice said, unless there is sort of an immediate threat, when you have a wire on somebody, when you're listening to every conversation they have, and that person is a high profile drug dealer, they're going to say a lot of things on there that reveal a lot of crimes. And some of them are going to scare you if you're listening to them. But pretty much, unless they say, okay, I'm going to go kill X now, right? The police aren't going to immediately arrest them. Now, if that happens, then unfortunately, despite the fact that you've got this ongoing investigation, you may spend a lot of time setting up, you're going to go have to interdict that, right? You can't let them do that. So I think Alice is 100% right. If they knew he was committing these crimes, these one set of crimes, but they felt like they could sort of monitor it and control it, and leaving him out was the way to go, then I can understand them doing that.
We would like to thank Brett and Alice for talking with us this week. Their podcast, The Prosecutors, is available on all major platforms. They've covered quite a few cases, and they always bring something unique to the table. It's definitely worth checking out.
To our surprise, we've gotten a number of requests from people saying they would like a way to help financially support our efforts with the show. So, if you are interested, we are relaunching a Patreon page, which you can find at www.patreon.com/murdersheet. Join us there for 2 live video question and answer sessions each month. You can ask us anything, suggest new cases for us to look at, or even offer ideas for new leads for us to follow. If Patreon is not your thing, you can buy us a coffee at www.buymeacoffee.com/murdersheet. Thanks for the interest.
Thanks for listening to this episode of The Murder Sheet. As always, thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
To keep up with the latest on The Murder Sheet, please make sure to follow us on Instagram and Twitter at Murder Sheet, and on Facebook at M-Sheet Podcast, or by searching Murder Sheet. If you enjoy listening to The Murder Sheet, please leave us a 5-star review to help us gain more exposure. And send tips, suggestions, and feedback to murdersheet@gmail.com. Thanks so much for listening.